Welcome to the first in a series of videos designed to help journalists become more familiar with how to cover criminal cases in Kansas courts. This video was created by the Kansas Bar Association's Media Bar Committee, which seeks to foster mutual understanding among journalists, judges, and attorneys in Kansas. We hope that by the end of this video, you'll know the basic procedures for beginning a criminal case in Kansas State Court, the factors that go into where a case is charged, and the procedures for requesting a probable cause affidavit under Kansas law. A criminal case begins, obviously, with the actual or suspected commission of a crime. Crimes are generally classified into crimes against people, crimes against property, or crimes against society. Criminal offenses under Kansas law are all listed in Chapter 21 of the Kansas statutes, which are available online. Some minor or common offenses are charged in municipal court instead of state court. Other crimes that violate federal law, such as crimes that affect multiple states, can only be charged in federal court. The legal standard to arrest someone is probable cause that they committed the crime. Probable cause means more than just a hunch or suspicion, and must be tied to facts. But those facts can be wrong or incomplete, and under the U.S. Constitution need to be proved beyond a reasonable doubt, a much higher standard. There are generally two types of arrests: an arrest on a warrant, which was issued by a court after a review of factual allegations by the prosecutor, or in some cases, a grand jury made up of citizens, and an arrest by police made in the field without formal charges having yet been filed. It is important for reporters to know that just because someone is arrested on suspicion of a crime, they are not formally charged with a crime until a prosecutor's office files those charges in court in a criminal complaint. Sometimes suspects will appear on a booking log, having been arrested by police on suspicion of a crime. But it's possible that when prosecutors review the arrest report, they'll decide more investigation is needed or that charges should not be filed. And remember, either way, at this point, these are only allegations. It's the prosecutor's job to prove the charges beyond a reasonable doubt. Sometimes, instead of being arrested, people are issued a summons to appear in court at a later date. If someone's been given a citation, it is similar to an arrest in that it doesn't necessarily mean formal charges have been filed, so it's best to check with the court or prosecutor's office. In some jurisdictions, a ticket or citation is the same as a charging document. Now that you've picked up on the news of an arrest or criminal charge, how can you figure out what court the suspect may be charged in? And how do you find out more information about the case itself? One of the best things you can do is take time to learn about what local courts exist in your community. Most major crimes in Kansas are charged in state court. Our state trial courts are organized into 31 districts. Every county is part of a judicial district. Some counties like Johnson and Douglas are big enough they have their own district. Larger districts have multiple judges, each judge making up a division of the district court. Some districts also have magistrate judges who handle limited types of hearings, such as first appearances, pretrial motions, or even some misdemeanor trials. All the key documents in a criminal case, including the criminal complaint, motions, and written rulings by the judge, are entered into a public court file with a unique file number. Make an effort to meet the chief judge of your district, the court administrator, and the clerk of the court, and to learn about the procedures they have in place for filing of case records and review by the public. There are also municipal courts which have limited authority and handle things like traffic, DUIs, or other common offenses that occur within city limits. Finally, some cases may be filed in federal court, what's known as the U.S. District Court for the District of Kansas. Our federal courthouses in Kansas are located in Topeka, Wichita, and Kansas City, Kansas. The U.S. Constitution provides the same fundamental rights for criminal defendants, whether they're charged in federal court or state court. Many of the same rights guaranteed to defendants by the U.S. Constitution, such as the right to a speedy public trial, are also enshrined in the Kansas Constitution's Bill of Rights. But the procedures and rules in federal court are much different, and for purposes of this slideshow, we'll focus mainly on covering Kansas state court proceedings. Where a case is charged depends mainly on two factors: the location of the arrest or alleged crime, and the type of crime being charged. For example, someone arrested outside of city limits for DUI would not be charged in municipal court and would instead be charged in state district court. Another example: a murder charge will usually not be filed in federal court unless there's a specific federal law that covers it, such as a murder that occurred during a bank robbery. People who are arrested on suspicion of a crime, either with or without an arrest warrant, are usually booked into the county jail. The jail booking log is open to the public by state law. For some alleged crimes, defendants may be able to post a bond right away for a set dollar amount and are released from jail to appear at a future court date. For more serious crimes, defendants are held in jail until they can see a judge at what's called a first appearance. In a first appearance, the judge describes the charges and asks if the defendant understands them. If the defendant cannot afford an attorney, the judge will appoint one. The judge then decides the amount of the bond, considering a number of factors set out by Kansas statute, including the severity of the crime charged, the danger to the public, and the risk of the defendant fleeing the jurisdiction. Now, you may have heard the term arraignment, which is different from a first appearance. In Kansas state court, this typically occurs only after a preliminary hearing in felony cases. At arraignment, the judge may read the full charging document to the defendant and must provide that defendant the opportunity to plead not guilty. Arraignment also begins the running of the clock for speedy trial requirements. For defendants in jail, that means the state has 150 days to bring the case to trial, or 180 days for defendants who are in jail on more than one case. Now that you know someone has been charged with a crime, how do you find out the details? Police are required by Kansas law to create a standard incident report. This will tell you some of the basic information about the alleged crime, such as the time and location. More detailed information is available in a probable cause affidavit, which will only be released under certain circumstances. You have an advantage over reporters in the 80s, 90s, and 2000s. For almost 35 years, probable cause affidavits in Kansas were all but closed by statute, leaving the public to guess and speculate about what actually happened and why certain suspects had been charged until there was an actual hearing or trial. That changed in 2014 after outrage over a Johnson County couple's home being raided on suspicion of being a marijuana grow operation. The family was actually growing a hydroponic vegetable garden, and given that they were never charged with a crime, had to fight in court to obtain the search warrant for their own home. Under the revised law, anyone can request that probable cause affidavits be made public, both a warrant for an arrest and a search warrant. A search warrant affidavit can only be obtained by the public after the warrant's been executed. There are resources available for how to obtain a probable cause affidavit, including this link from the Kansas Judicial Council. When you make a request for an affidavit, the clerk of the court must promptly notify the defense attorney, prosecutor, and judge, who have 5 business days to either propose redactions to the documents or file a motion to keep the documents private or sealed. No later than 10 days after notice of the request, the judge must act on the request by either ordering the affidavit released with any redactions or order that the affidavit or sworn testimony be sealed and not open to disclosure. The judge decides what should be sealed and what was an appropriate redaction based on whether it falls into one or more categories of information listed in the statute, some of which are broad and open to interpretation. Among the main categories, information that would jeopardize a victim or witness well-being, interfere with any prospective law enforcement action, reveal confidential investigative techniques, or be a clearly unwarranted invasion of personal privacy. That last term is defined to mean highly offensive to a reasonable person and totally unrelated to the alleged crime, and can only be used for redactions. If you disagree with the judge's determination, it may be time to call your legal counsel. Keep in mind that judges and attorneys are bound by ethical rules that may limit what they can and cannot say about a pending case. For example, the rules prohibit attorneys participating in a case from making out-of-court statements they know will have a material, prejudicial impact on the proceedings. That could include comments on a witness or defendant's criminal record, the existence of a confession, or a possible guilty plea. Judges are allowed to explain court procedures, but are prohibited from making any public statements that could reasonably be expected to affect the outcome of a pending case. For background on the court's procedures and what comes next in a criminal case, you can always contact the Kansas Judicial Branch Public Information Office. But know that court employees are subject to the same restrictions as judges on what they can or can't say. To recap, the steps leading up to a criminal case are the commission of an alleged crime, an arrest and booking into jail, and a first appearance by the defendant. Remember, charges by a prosecutor are only allegations until they're proven beyond a reasonable doubt. What type of crime it is and where it was committed determine what court a case will be charged in. And remember that you as a journalist can make a request to obtain the signed affidavit providing details of the alleged crime. Next up, in part 2 of this series, we'll tell you about the pretrial, trial, and post-trial procedures in Kansas State Court.